All right, I understand we're here today on the defendant CSI's motion to disqualify, is that correct?
Yes, sir.
Okay. And I guess you've seen, or you want to respond to their issue on standing that was raised in their response?
Of course. I intend to address everything before the court. As I understood the court's instructions yesterday afternoon, there will be a 5-minute or so opening by each side.
Sure.
With the recording devices present. At the end of those opening statements by each side, that aspect of the meeting will leave, and then we will begin the actual presentation of the motion itself.
Yes.
And I'm prepared to begin my opening statement.
Okay.
The court, please.
You may.
Thank you, Your Honor. Again, George Spencer, one of the attorneys for defendant, Church of Scientology International. Yesterday, in his opening remarks in this courtroom, plaintiff's lead counsel, Ray Jeffrey, made it very clear that the chief goal of this lawsuit is to pursue and attack David Miscavige, who is the leader of the Church of Scientology. A quote from Mr. Jeffrey yesterday. Our basic premise is there is really one man behind this harassment of Mrs. Rathbun. That was yesterday. 2 weeks ago, on August 28th, Mr. Miscavige's attorney, Lamont Jefferson, filed a document titled Special Appearance on behalf of Mr. Miscavige, his client. And in that special appearance pleading filed with the district clerk in this court, Mr. Jefferson very properly urged that while the plaintiff, Mrs. Rathbun, is of course entitled to her day in court to see if she can in fact prove her allegations against Mr. Miscavige, she must do so in California. Mr. Jefferson, Mr. Miscavige's attorney, set that special appearance hearing for the 12th, for yesterday. In response, and because the legal arguments advanced by Mr. Jefferson on behalf of Mr. Miscavige were so clear and so well settled under Texas federal and constitutional law, Mrs. Rathbun's attorneys decided that they would try a desperate move to keep this case against Mr. Miscavige here in Texas rather than refiling it in California and pursuing it there, which is the appropriate location. Mrs. Rathbun's counsel decided to get her husband, Mark Rathbun, to give an affidavit, a sworn statement made under oath, the same oath the witnesses taken in this courtroom, that they hoped would be enough to at least tie up Mr. Miscavige in Texas courts for some extended period of time. They filed that affidavit of Mark Rathbun along with an amended petition on September 4th. As I said, it was a desperate move, and I chose that word deliberately. There is, of course, absolutely nothing wrong with plaintiff's counsel attempting to keep their client's case against Mr. Miscavige here in Texas, provided they do so within the bounds of the law and provided they do so ethically and appropriately. But in their zeal to do whatever it takes to go after, as Mr. Jeffries said yesterday, this one man, David Miscavige, they crossed a huge ethical line. They didn't just put a toe over that line, they jumped over it and came down hard with both feet on the other side of it. In the affidavit that Mark Rathbun, the plaintiff's husband, swore to, and that plaintiff's counsel filed in this case on September 4th, Mr. Rathbun sets out under oath how he was intimately involved in and knowledgeable about the legal affairs of both my client, Church of Scientology International, and our co-defendant, RTC, Religious Technology Center. He said that for over 20 years, no legal litigation matter could occur involving either of the defendants, both my client and Mr. Jefferson, without his involvement or knowledge. And in an effort to keep this case in Texas, Mr. Rathbun described not simply the hiring of lawyers or attorneys in Texas, arguably a legitimate object of testimony and evidence in this context, but he went way beyond that and described the supposed substance of the communications between himself as a legal affairs person and the attorneys. Now, Mr. Rathbun's description of the substance, of the content of his communications with those Texas attorneys is false. But that is not the issue for today. That falsity can and will be dealt with fully at a later date. Instead, what is important, what is the focus of this morning's hearing, is that on its face and unmistakably, Mr. Rathbun's affidavit purports to reveal confidential, privileged communications he had while he worked on the legal affairs of the defendants and that he had with the attorneys for the defendants. It's impossible that plaintiff's counsel could miss this blatant breach of attorney-client privileged communication. It's impossible that plaintiff's counsel could not know, impossible that they were not fully aware of the importance to our system of justice that clients be able to speak freely, openly, to their own attorneys, with the assurance that those free and open communications will not be revealed and cannot go out of the room in which they were spoken. Now, plaintiff's counsel have done this. They filed Mr. Rathbun's affidavit as a public record, and as a result, the course of action that this court is to take is clear. Plaintiff's counsel must be disqualified under Texas law. They are working with the plaintiff's husband on this case. The plaintiff's husband, Mark Rathbun, was, by his own sworn admission, filed in this court less than 2 weeks ago, intimately involved in the legal affairs of defendants for decades. He is conclusively presumed under the law to possess, quote, confidential information, close quote, a technical term which is expansive and goes far beyond simply privileged communications. It includes privileged communications, but it is expansive and includes everything that Mark Rathbun knows relating to the legal affairs of these defendants, both privileged and unprivileged, that he learned during the time he was working on the legal affairs. We would be in a totally different situation, perhaps not even here at all on this day, if plaintiff's counsel had properly and appropriately taken precautions to prevent Mr. Rathbun from revealing the confidential information he has. Indeed, the case law, the reported case law in Texas, is an analysis. The reported cases in Texas are analyses of whether the person with confidential information was properly and thoroughly and completely advised of the critical importance that he not reveal that confidential information to the attorneys, and whether sufficient structural safeguards were built in to the attorney's relationship with the person such as Mr. Rathbun to prevent inadvertent disclosures of confidential privileged information, the so-called Chinese wall, as many court opinions have likened it to. But those are not the facts here. That is not what is before this court. No, the fact here is that on its face, in the affidavit of Mr. Rathbun that was attached to the pleading that the plaintiff's counsel filed in this case, is a revelation of several pieces of confidential information, including the purported communications with lawyers in Dallas about bringing a suit in Texas, which is their attempt to show that Mr. Miscavige should be required to litigate here in Texas rather than California. That affidavit conclusively proves that Mr. Rathbun is sharing confidential, even the highest level of confidential information, privileged information, with plaintiff's counsel. And when that occurs, when it is established that a person such as Mark Rathbun has revealed confidential information to the other side's lawyers, then the law, as repeatedly expressed by the Texas Supreme Court, requires disqualification of those attorneys. My client, CSI, does not have to risk further improper disclosure. As the Supreme Court described it in the American Home Products case, which we gave a copy of that to the court yesterday evening.
I read it.
Yes. As the Supreme Court said, the risk that a person who has functioned as Mark Rathbun did, the risk that he may disclose confidential information to the other side, quote, is unacceptably high. Now, plaintiff's counsel, both in the initial response that they filed yesterday and in the supplemental response that they handed to me out in the hall here a couple minutes ago, have no valid response to the line of Texas cases that controls. Instead, what they engage in, quoting Wikipedia, a source that I think we heard yesterday, if you rely on Wikipedia, you believe Mr. Rathbun is dead. But they resort to polemical statements, polemical arguments, and to the extent that they have a legal response, one rooted in case law and in authorities, what it is to cite to a completely distinguishable and inapplicable line of cases that are in parallel, but are distinguishable and are not applied in this situation of a person who was actually working in the legal affairs of a party and then goes over to the other side. And I will address that in much greater detail about the distinction between those kinds of cases. But the ones they cite are not applicable to this situation. Let me say, to wrap up this part of my presentation, I take no joy in bringing this motion, but it needs to be done to safeguard the rights of my clients. And I know you take no joy, Judge Waldron, in having to disqualify lawyers, but you do so to safeguard our system of justice. I was among the lawyers for the American Home Products case in the Supreme Court that I just mentioned, and I filed that motion because it also had to be done. Sadly, this is the second time that I have had to bring a motion such as this against these very lawyers. But at the end of the day, my personal feelings about this are really not important at all. And important, but not supremely so, is the fact that this is not the first time that these lawyers have crossed this ethical line in litigation against my client. What is of paramount importance is that under the undisputed facts, the facts established by the affidavit of Mr. Rathbun, which is in the court's own file, is that confidential information of my client, CSI, has been revealed to plaintiff's counsel and they've misused it. They must be disqualified further with respect to this. Thank you.
On behalf of the plaintiff and also on behalf of my co-counsel whose disqualification is being sought by the defendant as well, although they are both being subjected to this highly offensive, dilatory tactic, as am I, and they may need to interject at some point as well, which I think is their right. Your Honor, I would be amused at the manufactured tone of outrage by Mr. Spencer if it weren't for the fact that what he's filed is a motion saying that I and my co-counsel are guilty not only of unethical but immoral conduct. And it is a completely and utterly baseless motion, which we will demonstrate. So there's no amusement here. After 30 years of a distinguished career, double board certified, the highest ethical ratings, never having had any accusation of this sort other than from this lawyer right here who makes these ending remarks about how this is so painful for him. It's not amusing. And let me tell you, this motion is outrageous. And we do intend to file a motion for sanctions under Rule 13 for the court to punish them for this dilatory tactic. One point I would like to make to the court right here is if you read cases about disqualification of attorneys, the appellate courts, including the Texas Supreme Court, emphasize to the trial judges, watch out. Danger, danger. Motions to disqualify attorneys are the perfect grounds, the perfect tool of someone seeking a dilatory tactic. That's what you have here. The single most infamous litigant in the United States of America for dilatory tactics is the Church of Scientology and all of its corporations. If you look at our initial response, which we put together very quickly, we have some materials in there concerning the history of this church's attack on judges, witnesses, lawyers, parties. Now, their complaint, and you notice they never get really specific about what is this highly confidential material that was released by these lawyers in some great unethical act. Let me tell you this, Your Honor. Every word in that affidavit of Mr. Rathbun, which we were forced to file because of Mr. Miscavige, Captain Miscavige's false affidavit, saying he didn't have any connection with the state of Texas. He didn't even know Monty Drake, who had worked for him for 15 years. We had to get proof of the contacts with Texas. So, did I receive, Your Honor, some confidential, privileged information from Mr. Rathbun that went into that affidavit? Everything in that affidavit I already knew. Your Honor, it is all in the public domain, every single word. And what is so disgraceful about this motion is that they know it. You heard yesterday that just of Mr. Rathbun's writings, they have 25 or is it 27 big 3-ring binders of every word he's ever written. The stuff in our affidavit, this is a best-selling book published just this past year by Pulitzer Prize-winning author Lawrence Wright. The one that kind of started it all, the first really true outside history of the Church of Scientology by Janet Reitman, called Inside Scientology. All the stuff I was talking about yesterday, the Guardian's office and how things operate, it's all in these books. By the way, Mr. Rathbun, and we'll offer all of these, Your Honor, in the course of this hearing. Memoirs of a Scientology Warrior, The Scientology Reformation, What is Wrong with Scientology, with a picture of the Squirrel Busters that you saw yesterday on the cover. It's all in the public domain. Well, what about the best I can tell from their motion is that, gosh, if you look at paragraphs, was it 61 through 65, I think it is, where Mr. Rathbun talks about having hired on behalf of Mr. Miscavige the Jenkins and Gilchrist law firm in Texas. Nothing in there says anything about what was said. He's not quoting anybody or Joe lawyer said this to me. But he describes his contacts on behalf of Mr. Miscavige in the state of Texas. Guess what, Your Honor? As they well know, that was the subject of Mr. Rathbun's examination under oath in a Florida federal case last year. The exact topic in greater detail was filed in federal court in Florida. Mr. Rathbun, by the way, isn't a part of that case. He was subpoenaed, and he appeared, and he gave his examination under oath. In fact, he tried to resist it. The exact thing that Mr. Spencer has manufactured this outrage about was filed in federal court last year. It is attached to our supplemental response that the court has. it is their burden to show that this, first of all, that this information is privileged or confidential. All of this information, when it came to little old me, was already in the public domain, and I was familiar with it. I've read Reitman's book. I've read Lawrence Wright's book. I had read the examination under oath of Mr. Rathbun, which is on the internet. If they had merely Googled a few simple searches, they would see that everything that they're so shocked about is out there. How is that confidential? So, number one, the evidence that they're crying about is not privileged or confidential. It's in the public domain. Number two, as the court is well aware, waiver is a gigantic issue when it comes to matters of confidentiality and privilege, because the whole concept of confidentiality and privilege is, the overarching concern is we need to keep this secret information close to our vest. We don't want the world to know about it. Mr. Rathbun spoke out for the first time in 2009. He has spoken out in the media. He has given print and television interviews. He's written 3 books. He's been the subject of a documentary. He has been called as a witness or listed as a witness in numerous cases, including all 3 of the cases Mr. Spencer has been involved with. And guess what, Your Honor? Never once, ever, from coast to coast, they have over a dozen lawyers in this courtroom. That's how lawyered up these people are. Never have they sought a protective order, a gag order. Have they sued Mr. Rathbun when he's listed as a witness? They don't go and seek some kind of a protective order saying, oh my goodness, we cannot have this confidential, privileged information get out into the public domain. No, it is a consistent strategy in every case. They know that Mr. Rathbun is one of the most knowledgeable human beings in the world about what's going on or what has gone on in the Church of Scientology. And that he would very likely come up as a witness to the extent that the practices and procedures of the church come into bear in some litigation. And when he's listed as a witness, or he gives a declaration, or an affidavit, or an examination under oath, they don't claim privilege. They don't go to the court and say, the court, don't allow him to testify about this. It's all top secret. Why? Because it would be ridiculous. It is all out there in the public domain. That is waiver. To be surrounded by dozens of lawyers and to review they're watching him like a hawk. That's why they have every word he's ever written in 27 3-ring binders. They watch him like a hawk. They video him. They do all of these things. They know, and they've never once taken any action to shut him up. Instead, they have this very clever dilatory tactic. Anytime an attorney seeks assistance from Mr. Rathbun, we'll just get the attorneys disqualified. There aren't too many attorneys willing to take on the Church of Scientology. They have filed motions to disqualify over and over and over again. That's the situation that we're in. That's why we're going to come back here and ask for punishment against them. What is another basis for waiver recognized by the law? And that is offensive use of the privilege. That's exactly what they've done here. They've come here and asked you for the ultimate relief in this case. For Mr. Miscavige, Captain Miscavige, and the RTC, dismiss us from the case. And Mr. Spencer very cleverly just said a moment ago, oh, well, gosh, Mr. Miscavige's attorney yesterday said, we respect the right of Mrs. Rathbun to sue us out in California. Look at his special appearance. It says this is nothing more than extortion. Your Honor, this is how they operate. I am an ethical, upstanding attorney. No information came to me that was privileged, and I decided in some sneaky, immoral, unethical way to throw that out there. This is information that I already knew from public sources, well aware of it, and that's one of the things the court is supposed to look at, is look at the attorney's behavior. I knew all this stuff, Your Honor. To make an offensive use of the privilege, that is, to come to court and say, Your Honor, we want you to do something for us. Dismiss us from this case. We don't want to appear and answer these very serious charges in Texas. And here is the sworn affidavit of the president of RTC and the captain of the Sea Organization and the Pope of Scientology. Here they are. Don't question, don't offer any information in response that shows that these affidavits are false, these declarations are false. That is an offensive use of the privilege. Again, if we get back to the purpose of the whole law surrounding privilege is to keep concealed, properly concealed and concealable things, secrets, is to keep them secret. For the last 5 years, they have made zero effort to keep any of this stuff secret. Why? Because they know they can't. Instead, we have a dilatory tactic, which is, okay, this stuff's already out there, everybody knows about it, but we're going to attack the lawyers in every case. First, attack the lawyers. That's where we stand with this thing. One last thing I would like to caution the court, and we can argue about the law later on these cases, is Mr. Spencer pounding his fist and saying that the law is clear and this is what it stands for does not make it so. He cites 3 white horse cases that he tells you means you must throw these lawyers out of this case. You know what all those cases are? The classic situation of a paralegal works at a law firm on one side of a lawsuit. Sometime later, the paralegal goes over and works for the law firm on the other side of the lawsuit, which, by the way, you can do. You have to have precautions and screens and firewalls. That is not remotely what we're talking about here. That's a person, that would be like if we were 6 months down the road and Alan Cartwright over there, the director of legal affairs for the Church of Scientology International, if he showed up in my office and said, I'd like to go to work with you on this case as a paralegal, and I want to work on this case. Well, if I did that, I'd be an idiot. That's not what we're talking about. The only thing that Mr. Rathbun talked about was his personal experiences, which, by the way, under the law are not privileged. Communications are privileged. Talked about his personal experiences with regard to a legal matter in Texas, what, 20 years ago? It's relevant, but it has nothing to do with the merits of this case today. The only reason why it even comes into this case is that they have come to court and asked you for the ultimate relief, dismiss us from this case. The material is not privileged. They know it's not privileged. They have an obligation, if they want to claim that it's privileged, to protect it. They have never protected it. By the way, what you have right there attached to the supplemental response, the testimony under oath of Mr. Rathbun from that Florida federal case. You know what the church defendant did in that case? They said, well, that's hearsay and it's not true. Where was the claim? Well, gosh, that was privileged information. That's confidential information that the church tried to get the fix in with the federal courts in Tyler, Texas, with the Jenkins and Gilchrist law firm and their local counsel. Where was it? Your Honor, this is a despicable motion. They ought to be ashamed of themselves. And for Mr. Spencer to get up here and say, oh, this is made even worse by the fact that I did this against, I hate doing these things, but I had to do this against these same lawyers in another case. We attached to our initial response the response that we were going to file to that ridiculous motion in South Texas, showing that it was completely bogus. He asked me not to. They withdrew their motion. Did he mention that anywhere in his motion to disqualify us in this case? That he withdrew that motion in exchange for me not filing my response, showing that it was total garbage? So twice now, I have been called immoral and unethical, and that I filed something heinous and all of this other stuff, and this is absolutely wrong. I don't know what other than all the submissions you have, we'll be happy to put on any evidence you want, argue the law in any way you want, but I'm just telling you, Your Honor, this is a baseless motion brought for dilatory reasons, and we're going to be back here asking you to sanction these defendants.
Judge, I know that you're attracted, but I do just want to respond to Mr. Jeffrey's attack on me personally about the same precinct.
Well, I think it right now was a tit for tat. There were some personal attacks flowing both directions. Can we just save it for argument at the end of the day?
As you wish, Your Honor.
Thank you. Okay, before we get into any further aspects of this hearing, I would just ask at this time that any recording devices, as we make it in the